10 Things You Should Know about Spain's civil registry system and its records, before starting Spanish family tree research. Nationwide civil registration of births, marriages and deaths officially began in Spain on the relatively late date, compared to other Western nations, of January 1, 1871. Legislation requiring the recording of this data, and shaping a standardized, nationwide system, had been passed the previous year by the Spanish Parliament. It's important to remember that this national legislation resulted in records created and stored only at the local level. Ultimate authority over the registry offices rests with the Ministry of Justice in Madrid, today through its division called the General Directorate of Judicial Security and Public Trust. For over 100 years, however, all of the records created within this framework were kept on paper in large, bound ledgers at the municipal level, with no copies made for the provincial, regional, or national administrations. This is why, to locate a civil record in Spain, it is absolutely imperative to know the city, town, or municipality where the event was recorded. Today, registry offices in Spain vary enormously in terms of staff, size, and resources. Those of large cities such as Madrid, Barcelona and Malaga occupy dedicated buildings, have a large staff and yet frequently a heavy backlog of work. This situation is shared by some towns and cities one wouldn't necessarily think of as large for historical purposes when requesting a record generated in, say, 1910, but where the population may have risen sharply in the past 10 or 20 years owing to immigration, resulting in a much larger volume of recordable acts than took place in the same towns a century ago. Those in small towns are likely to consist of one room in the town hall, staffed part-time by a court secretary, who also deals with other duties and is under the oversight of the local justice of the peace. In some rural areas, the records of several municipalities with dwindling populations have been grouped together under a single official, who is likely to also be on duty only part-time. With each generation, this is becoming more and more the norm in some areas, as people leave the countryside and move to cities. Despite these huge differences, from one registry office to the next, the record types are standard at all of them. The different events recorded are grouped into sections, and these sections are the start of the reference number used to identify any given record. Section 1 – Births. Section 2 – Marriages. Section 3 – Deaths. So, for example, the reference for someone's birth record could be the name of the city, Section 1, Book 45, page 116. Note that all events are recorded in the registration district in which they take place, regardless of whether that is the legal residence of the person named in the record. Although legislation in 1870 provided for the printing of standardized ledgers, with blank entries to be filled in for a person's vital details, many early registry entries were made entirely by hand, and such entries can be found in ledgers as late as 1900, sometimes even later. The format and information recorded varies somewhat from town to town, but all birth records should provide the full names and places of birth of both parents of the infant. They may also provide the parents' ages. Likewise, some identification of all four of the infant's grandparents should be provided on each birth record. The level of detail can vary greatly, depending on the inclination of the clerk who filled in the record. The grandparents' full names, given and two surnames, may be given, their places of birth, their current age and current place of residence, or it may just be their first names, places of birth, and whether or not they are still living. Marriage records should provide the full names of both spouses, usually, but not always, their ages, and varying levels of detail about their parents. Death records will provide the full name of the deceased, their age, not always accurately, and varying other details, such as profession or last address. Initially, death records named surviving spouses and children, but they stopped doing so around 1960. And as stated above, these records will be found where the death actually occurred, not where the person lived. And not necessarily where they were buried. For example, if, by chance, someone happens to die on a bus as it is passing through a town where they'd never been before, the death will still be recorded there, and not at the registry office of the town where they actually lived. Handwritten Spanish civil records have a roughly 1.5-inch blank space that runs along the left margin to facilitate marginal notes. In theory, when a person married, and when they died, a marginal note should have been placed on their original birth record, adding those details. Likewise, if a marriage has ended in divorce, the date and place of the decree should be noted on the original civil marriage record, in the margin. In recent years, notations have also been made when someone used their birth record to request a national identity card, known as the DNI for short. This reference to the date and place of issue is sometimes useful in research, if one does not know where the person has lived as an adult. Many other things can be mentioned in marginal notes. They include the renunciation of Spanish citizenship, if the person named in the record has become a citizen of somewhere else, and delayed acknowledgement of paternity, if the person's father was not originally named in the birth record. Since 1957, at the time of one's marriage in Spain, the civil registry also issued couples with a booklet called the Libro de Familia, or family journal, in which births and deaths were recorded. The idea was to give each family a portable duplicate, in summary, of all of their records, with entries being made by the registrars from each office at which a birth, marriage or death was recorded. The issuance of new Libros de Familia has been phased out since 2010, but the existing ones retain legal validity for documenting any events that took place between those years. A person's Libro de Familia, if you have it, will tell you where to find and request copies of any births, marriages or deaths it references, and may be considered legal proof of any relationships shown. However, it may not be infallible enough to serve as exclusive proof, for example, to prove that a given couple had no children except those named therein. Of course, if a Libro de Familia were lost and a replacement issued to the holder, in theory there is the possibility for the new booklet to omit some of the data shown in its predecessor, through action or omission. In summary, Spanish civil registration records, from 1871 onwards, are precise as to a person's date and place of birth, and the parents' full names and places of birth, and the birth records are generally very useful for linking to that person's grandparents, as well. For genealogists, this link to another generation is one of the very best aspects of a Spanish birth record. In an era of constant mobility, this data about grandparents can be crucial to proving relationships, and to tracing a tree back to a family's place of origin. Spanish death records may turn up at unexpected locations, and as with genealogy in other places, records of a death are not a first-person statement about the person named therein, so they should not be assumed to be the most accurate among all possible records, but may still provide many useful details. To commission a search for your ancestors in Spain, visit www.spanishgenealogy.com.